We'll go to the next bill sponsored by Representative Cortravand. It is an act related to criminal offenses, trespass, and vandalism. It prevents a person from being prosecuted for fishing, gathering, seaweed, swimming, or passage along the sandy or rocky shoreline within 10 feet of the most recent high tide line. Representative Cortravand, the bill is yours.
Yes, thank you. So this is a simple bill, but actually when you get down to some of the concepts, they're pretty complicated, especially when you're talking about tides. But I want to just lay out some history of what got me interested in this and what I've learned in researching this issue. So in 1982, there's a case called the Ibison Case. And this laid the groundwork of what our current understanding of where private property lines and the state public trust interact at mean high tide. And mean high tide is determined over an 18.6-year cycle. And prior to that, the shore was more defined between the wet. It was not so specific, and people were allowed to walk along the shore. I think it became more prescribed after the Ibison case in 1982, which was very specific. And then we come to 1986 when the state had a constitutional convention. And at the Constitutional Convention, question 9 talked about expanding shoreline rights. And I can read the section of the Constitution that was actually adopted. This was a very popular measure. It was supported by 69.6% of the public voted in favor of this. Now, I did not live in Rhode Island at this time, but I'm sure many of you did. And I'm wondering, what were the voters' intents when they voted on this measure? But I would like, for the record, to read what's in our Constitution right now on Section 17, with fishery rights and shore privileges. Preservation of natural resources. The people shall continue to enjoy and freely exercise all the rights of fishery and the privileges of the shore to which they have been heretofore entitled under the charter and usage of the state, including but not limited to fishing from the shore, the gathering of seaweed, leaving the shore to swim in the sea, and passage along the shore. And they still shall be secure in their rights to the use and enjoyment of the natural resources of the state with due regard for the preservation of their own values, and it shall be the duty of the General Assembly to provide for the conservation of the air, land, water, plant, animal, mineral, and other natural resources of the state, and to adopt all means necessary and proper by law to protect the natural environment of the people of the state by providing adequate resource planning for the control and regulation of the use of the natural resources of the state, and for the preservation, regeneration, and restoration of the natural environment of the state. So that is what our Constitution says. So I feel like there is a conflict between what people voted on in this mean high tide, as evidenced by the recent event in South County, which is really what got me interested in this, by Mr. Scott Keeley, who I believe will be testifying. This bill is trying to address a problem where people do not understand exactly where this mean high tide is, and to just give property owners and Rhode Islanders and law enforcement and cities and towns a very clear-cut idea of where they can be, and that is 10 feet from the most recent high tide. And I actually have an image, if I could share that with you, because sometimes a picture speaks 1,000 words. Is that possible to do? Chairman? Is it possible to share my screen?
If that concludes your testimony, then we can move to witnesses. We have several witnesses that are signed up for this bill.
Yeah, I didn't know if I could show a picture.
Oh, sure, go ahead. Yeah.
Let's see, I'm gonna try this. Share my screen. Let's see, I don't know, I guess I don't really know how to do that. Maybe I don't know how to do that. Let's see. I guess I can't, maybe I'll have to email it to you. I don't, here we go. Can you all see that?
Hello.
Can you see the image on my screen?
No, we can't. Why don't you email it? Oh, there it is, yeah.
So that shows the most recent high tide and where 10 feet would be. And if you can think of 10 feet is just a little bit longer than a large beach towel. So I just wanted to give you a visual of what we're talking about. So this aims to just provide some clarity for people of where they can and cannot be. It does not mean to change the property lines. It does not do that. So I want to be clear about that. All right.
Okay, we'll go to the witnesses. The first witness is Scott. Scott, are you on the air?
I am.
You could testify.
Hi, my name is Scott Keeley, and I'm testifying in favor of H5469. I was wrongfully arrested for willful trespass in June of 2019 on a Sunday. The charges were dropped on a Monday and the record expunged by Wednesday. And the story of my arrest is public record, as is the video of the event. I'd like to add that the arresting officer and I agree with his statement in the police report. And of note, the attorney for the town of South Kingstown admitted to my attorney, Brian Kuna, that in his words, Mr. Keeley was polite to the officer the entire time. Now, as I understand it, the evidence shows the South County Police changed their policy on that Monday after my illegal arrest. The arrest was made because the police department had agreed, at least momentarily, that the Constitution implied that one had to remain in motion to exercise their rights along the shore. They changed their stance after my arrest, and therefore, thereafter, the South County Police decided not to arrest anyone else along the shore for trespassing. And no one has been arrested that I've seen, though many have exercised their rights to the shore there. So I don't need to worry about being arrested when I go to the shore in my area. But I'm not here to testify for myself. I'm here to support H5469 because many people remain afraid to exercise their rights along the Rhode Island shoreline. In particular, in that same area where I was arrested, the homeowner continues to deny the public their right to the shoreline. I've witnessed the homeowner on numerous occasions telling people that they may not be on that beach. And when they refuse to move, she tells them that they may stay there for the remainder of the day, but they may not come back again. So she does, in fact, deem their presence the public use of private property. H5469 does not ask that illegal activity be suddenly deemed legal on the shore. It asks that we not be arrested for exercising our constitutional rights, and it defines where they may be exercised. So the bill makes what is implicit in the Rhode Island Constitution now explicit without extending or adding any new rights. The rights and the privilege of the shore are uniquely site-specific. Our rights to the shore require space along the shore, and I feel that H5469 simply confirms where the rights to the shore, as set forth in the Rhode Island Constitution, may be exercised. You know, the Constitution, as well as the bill, states a number of things that can be that are part of our rights to the shoreline, but it states that they are including but not limited to. And if only these listed activities were to be allowed and you had to be in motion, the statement would have read consisting only of or consisting solely of rather than including but not limited to. But they did not. They are listed as including but not limited to. So one aside that I'd like to make is that Our shoreline in the ocean state is not growing. And in the area where it recedes, we're forced to ask, have all the residents of Rhode Island lost their rights to the shoreline? And will property owners then attain the right to exclude others from their rights? So, the Rhode Island Constitution does not state that any amount of taxes paid gives the right to the payer to exclude others from their constitutional rights to the shoreline. We've seen signs put up, illegal signs, according to the CRMC, that have been taken down. We've seen signs that say private property on property that's actually owned by the town of Charlestown. We've seen ropes, fences, piles of rocks, and even signs that say dune restoration when no restoration project has been initiated. So H5469 does not ask that illegal activity be deemed legal. It asks that we not be arrested for exercising our constitutional rights, and it defines where those rights may be exercised. Thank you for your time.
Thank you, Scott. The next witness is Joel Gerstenblatt. Joel, you on?
Yes, I am.
Bob Craven, you...
Hi, Bob. How are you?
Good, yourself?
Good.
Fire away.
Oh, I didn't realize I was on.
You're on the air.
Oh, okay, thank you. Mr. Chairman and members of the committee, I just would like to thank you for this opportunity to make our position known. I am a board member of the Pawtucket by the Sea Association. This association was established in 1953 and owns waterfront property along the Green Hill area of South Kingstown. We have always respected the rights of Rhode Island residents to pass along our shore, to enter our water to swim, to fish and collect seaweed. I've been a member for the past approximately 7 years, and again, this association goes back to 1953. It consists of many full-time residents of South Kingstown and some seasonal residents as well who pay taxes to South Kingstown. We've never had any issues with allowing members of the public to enjoy the waterfront, swim, fish, collect seaweed, whatever they want to do within the confines of the Constitution and so forth. We are in opposition to this bill. We think that it will hinder the South Kingstown Police Department and any other police departments that are involved in the southern waterfront areas of our property. The definition of prohibiting activity or allowing activity within the 10 feet of the most recent high tide line, I think, poses a problem for enforcement and also poses a problem for the resident or for the Rhode Island resident who wants to enjoy this shoreline. The tide line changes consistently. It changes twice a day. What is legal or not legal at 8 o'clock in the morning may be the opposite at 8 p.m. I think it poses many difficulties and is attempting to amend the Constitution without going through the proper means. And as the Pawtucket by the Sea Association wishes to note its objection to this bill, and I assume that there are other small beach associations along the South Shore, the West Bay, the East Bay, that also would have the same position. And again, I thank you for your time.
Thank you, Joel. Any questions of Joel Gerstenblatt? Seeing none, Dave McLaughlin with Clean Ocean Access.
By the Sea Association wishes to note its objection to this bill, and I assume that...
Dave, you on the air?
I am.
All right. You can testify.
Thank you very much. Good evening. My name is Dave McLaughlin. I am the Executive Director of Clean Ocean Access. We're an environmental nonprofit based in Middletown, Rhode Island, working predominantly in Newport County. We formed as an organization in 2006 specifically because of an issue with public access, where we felt as if something that we've enjoyed forever was being taken away from us. And that's really what started our organization. But I wanted to just go back a little bit further to 1978, when a mandate was provided to the Coastal Resources Management Council requesting them to designate a right-of-way for approximately every mile of coastline in the state of Rhode Island. Great effort was made in the 80s into the early 90s. Almost 222 rights-of-ways are legally defined. Since that time, the number has crept up to almost 230, but there's still at least 170 rights-of-ways that still need to be defined. Now, the reason I mention that is because getting to the shoreline to enjoy ocean activities is the most important thing for everyone in the state of Rhode Island to be able to enjoy the ocean. The reason we care about the ocean, the reason why we have an economy that thrives on a healthy ocean is because we can get there. So I want to just commend the work of CRMC to build these rights-of-ways and work with the communities to define these. But then when you get to the shoreline, you do have the option of going in the water, but you also have the option of traversing the coastline. And when you think about moving laterally across the coastline, and you think back of the founding people that founded Rhode Island, Roger Williams is known for needing enough shoreline to render a right whale. Now, I don't think we'd be rendering a right whale today. But if you can imagine, that's a lot of space. And certainly going back to decades and centuries of collecting seaweed and fishing, the idea of having an ox cart's length. Now, you can say that these things should be done in such a way that it should be defined, etc. But the reality is everyone deserves a right to get to the shoreline, and everyone should be able to laterally move across the shoreline in a reasonable way. I think that the slide presented by Representative Cortavent does an excellent job of indicating how this is not changing the definition. It's just providing an allowable, suitable amount of coastline to be used. And I want to emphasize, kind of as closing remark is, we all have a sense of responsibility to the shoreline, and that means that the people that are using it, as well as the people who are living adjacent to it, we all need to get along, and we need to act responsibly and protect the natural resource. So we are in support of H5469. I think it moves the conversation in the right direction. It creates the environment that's healthy for the citizens, it's healthy for our environment, it's healthy for our economy. Because if we can't get to the shoreline to enjoy it, there's not going to be anyone here. So those are my final remarks. And again, I really appreciate the effort of everyone to address this issue, and I look forward to seeing public access being protected, preserved, and expanded in the state of Rhode Island. Thank you.
Thank you, Dave. Any questions? Leader Filippi.
Thank you, Mr. Chairman. I just have a statement. I don't have a question for the prior witness. I just would like to add to the conversation. Thank you. Thank you, everybody. And thank you, Representative Court-Friend. We had actually collaborated on this, and we were really deliberate in what we did here. One of the large concerns that we have when we're trying to deal with this issue is we don't want to subject the state to some type of Fifth Amendment taking clause. Our Supreme Court has defined where the property line is. And if the state tried to redefine that property line or obtain some type of easement over land that the Supreme Court has already said belongs to a private landowner, we might subject the state to some type of Fifth Amendment, United States Constitution taking and subject the state to monetary damages. So we were careful in what we did here and said, in these disputes, we don't believe that the force of the criminal law should be used between disputes between a property owner and someone exercising their constitutionally protected rights. And so that was really the intent here. We've gotten some emails that I think it's important that we dispense with some misinformation out there. When you look at the specific language, it only applies to sandy and rocky shorelines. It doesn't apply to bulkheads. It doesn't apply to people's front yards if the high tide comes up that high. It really only involves what we traditionally know as the shore, traditional notions of the shore. It's not going to allow people to go on other people's curtilage around their house if the high tide has gone that high. It's important for us to be specific that this area, this 10-foot area, is only on sandy and rocky shorelines. And we also have to be cognizant of why that Ibison standard is no longer workable. And specifically, if the Ibison standard is this average high tide over an 18.6-year period, and we're in a time of receding shorelines, that average high tide line over the past 18.6-year periods is going to be out in the water. It's going to be out in the water during a normal high tide now that our beaches have shrunk. There would be no ability for Rhode Islanders to exercise their constitutional rights on many beaches throughout the state that have receded, and we all know they've receded over the years. And so the position of this really is we're not going to use the force of criminal law in a dispute between a neighbor and citizens exercising their rights. If they want to go the civil route and deal and enforce their property rights in the civil courts, they can. They can go seek a restraining order, but the force of the criminal law should not be used as it was against Mr. Keeley. That was inappropriate. I'm thankful that he has stood up for his rights. Many times if we don't stand up for him, they're lost, and I think he has done a great deed for all Rhode Islanders. And I think we as a body need to have the same gumption and protect the rights of the citizens of this state for something that is fundamental to being an ocean stater. So that's really it. I'm thankful for Rep. Cortfrin for running with this. It's something that we need to get past before this summer, because those of us in South County, those of us in the East Bay, we see the disputes every single day. And I can't tell you how many times I've had people call me saying that they were threatened with arrest by property owners, and they're with their kids. And they just kind of walked away from a beach day or had to go somewhere else because they were threatened. Their family was threatened with arrest by some property owner. We want to take those threats off the table. And I think we need to do it, and I think we need to have the same guts that Scott Keeley had when he stood up against his rights being taken, because it's happening every day in the Ocean State, thousands of people and visitors, and it's just wrong. We need to get the threat of criminal prosecution out of these disputes. Thank you, Chairman, and thank you, Rep. Cortfrin.
Thank you, Leader. Any further questions?
Chair, can I jump in?
You may.
It's Rep. Knight.
Yes.
Can everyone hear me? I'm on a different device now.
I can hear you.
I applaud Rep. Cortfrin and Leader Filippi in trying to tackle this issue. I think it gets super sticky. I talked to Rep. Cortfrin over the weekend and did a little homework on this case. And here's my concern, and maybe Leader Filippi can help me out a little bit here. If I'm a landowner and I have a plot of land that goes down to that 18-and-a-half-year watermark, right? Because the plot goes to the shore in the deed, and then we create and then we carve out an exception to our criminal trespass law, where at the high tide, presumably somebody could trespass up onto the landowner's property, but the landowner doesn't have the ability to call the police to eject them. What I'm worried about is some self-help situations coming up. I'm worried about making this criminal trespass law somewhat convoluted and not workable in court by creating terrain requirements of sandy and rocky. I know, Leader Filippi, that you've probably thought about the what ifs here. If I may, Mr. Chairman, if I might ask through the chair, do you have any thoughts about the potential for increase in self-help?
There's always concern.
I understand where someone feels they can't call the police, so they assault somebody, they get more verbal. Could it happen? Could there be more self-help if we pass this bill, Rep. Knight? Potentially. But I think that pales in comparison to the deprivation of rights. Could there be instances where there's conflict that wouldn't have happened if we hadn't passed this law? Potentially. If the implication is self-help is going to violate other laws, if there's going to be assault, then, we have other criminal laws that prevent that type of self-help. I don't mind if the self-help is verbal disputes. I think there should be more verbal disputes between people when rights are being taken away. And people want to exercise those rights. I think one of the reasons that we're here is because maybe people haven't stood up for their rights as much as they should have. It's not clean, Rep. Knight. It's not pretty sometimes, but the fears that you have, I assume, involve other criminal activity where someone seeks to eject someone from their property using force, and I just don't think people break the law that much where it would happen. I don't know if I answered your question. I guess it's your definition of self-help, which needs some clarification for me to really answer.
I appreciate that, Leader. What I'm concerned about is a landowner thinking that their property line runs to a certain point, and a person trotting over the land that is owned by the property owner because the deed says so, and says, essentially, you can't touch me because the criminal law is not going to touch me up here. You just think of like an overlapping 10 feet. And I know I might be what-ifing it to death because I'm assuming a trespasser who sort of knows the law, knows where they can be touched, knows where they can't be touched, and is kind of poking the landowner in the eye a little bit. I'm also assuming an unreasonable landowner who absolutely does not want anyone on that last 10 feet. But I think we're setting up a conflict in the law, and there's a saying that we all learned in law school, which is bad facts make bad law. I think Mr. Keeley's case shouldn't have happened, and from what I read in the newspaper, shame on the police for arresting him when he was clearly within his rights, no matter what the homeowner said. The Ibison case down in the last paragraph says that for a successful prosecution must show that the trespasser knew of the presence of the 18-and-a-half-year line and knew where it was. Presumably they couldn't do that in Mr. Keeley's case because that's why they chose. Well, presumably Mr. Keeley wasn't beyond that point. He was in the right where he was supposed to be. I just think that if we carve out this criminal trespass exception without addressing the rights of the landowner that abut the 18-and-a-half-year line, we're inviting trouble. That's all. But I have a couple of solutions in mind we could talk about offline.
So just to respond, in many of the South County shores, the beaches are eroding very, very quickly. And there are landowners who are doing surveys to show that 18.6-year line is in the water. And that's happening right now. So I guess I almost want to throw it back at you and say that the concerns that you have are far outweighed by what is actually happening. The hypotheticals that you pose, Rep. Knight, that may or may not happen, even if those were true, are far outweighed by what we know is happening now, the harm by what we know is happening now. And that is that this summer, there's going to be property markers which say where that Ibison line is, and they're going to be in the water during high tide, and now that trespasser is going to know where the property line is and have to walk above it, and the state would be able to prove that they knew beyond a reasonable doubt where that 18.6-year line is. So that's going to be happening all over beaches in South County this year, where prosecution will be enabled because there will be markers showing where that metronic cycle, which is the 18.6-year tide, is. So I think the evil we're talking about far outweighs the hypothetical evil that you're raising. There's no perfect answers here. I wish there were. It's what is the least bad. And I think what we're proposing is the least bad. And that's getting the criminal law out of this issue. Other issues may raise up, and we'll have to deal with them then. And I think most people are reasonable, and there's not going to be violence. It's not going to happen. There may be verbal disputes, but it's messy in a free society sometimes. Let's get the government out of these disputes, the criminal law out of these disputes.
Any other questions or comments by the committee? Hearing none, our next witness is Dennis Nixon. We just had a changing of the guard to let the chairman take a break.
Hello?
Oh, I'm Vice Chair Carol Hagan McEntee, for the record, as you all know. At least the ones that are looking at me do. So, Dennis Nixon, are you with us?
I am.
You're at the House Committee on Judiciary, and we welcome you. So you have the floor.
Thank you very much. My name is Dennis Nixon. I am resident of Jamestown, and I am recently retired after 44 years as a professor at the University of Rhode Island teaching coastal zone law. I followed the public access issue since I moved to Rhode Island in 1975 and became a member of the Rhode Island Bar. I'm not a lobbyist. I'm not here to represent anyone other than myself, but I'm very interested in the subject. In 1976, I wrote my first big law review article entitled Public Access to the Shoreline in Rhode Island. It wasn't exactly a bestseller, but it was the only one on the subject. And it documented the efforts by your forerunners in the General Assembly since 1957 to clarify shore rights and the long history of litigation. In 1986, because of the article, was advisor to the Rhode Island Constitutional Convention by Delegate George Sisson from Westerly, who headed the Shore Rights Subcommittee. I was asked by convention President Kevin McKenna to dramatically expand shore rights in Rhode Island, but I had to advise him as an attorney that to do so would violate the so-called takings clause in the Fifth Amendment of the United States Constitution. But what I could do was suggest that putting the leading shore rights, each upheld in separate Rhode Island Supreme Court opinions, in a specific article of the Constitution so that a subsequent Supreme Court could never eliminate those rights. My argument prevailed, and those four rights of fishing, swimming, passage, and gathering seaweed were incorporated into the Article 1, Section 17, which Representative Courtgreen has already gone through. And I was pleased that it did pass by the largest plurality of any issue on the ballot that year. One problem, however, remained. The Ibison case that she also cited in 1982 involving sport fishermen in Westerly, which did adopt the boundary of mean high water between public and private rights, basically adopting the standard that the United States Supreme Court set in 1935 in the case of United States versus Borax. But while the court adopted the boundary, as noted earlier, it could not find the fishermen guilty of criminal trespass because on a day-to-day basis, no one knows precisely where the boundary is. Mean high water makes for a good legal boundary to mark boundaries and deeds, but is terrible in terms of the complexity of figuring where it is when you simply want to use your constitutional rights to walk along the shore. Do we really want people facing criminal trespass charges when the boundary in question is a function of the average of high tides over the previous 18.6-year lunar cycle? When the shore, particularly along our south coast of sandy beaches and barrier islands, can see substantial erosion overnight after a coastal storm. That's why this bill removes the issue of criminal trespass when passing along the shore. And I'd like to differ with Leader Filippi on one point. You can't really have a boundary out in the water. If the shore has eroded, the property owner has lost that property. The new mean high water line is, as of that month, when you look at the 18.6-year average of the previous period, you stand, if that average, say, for example, it's a 3-foot rise over the 18.6 years, you go to that day of the month when the tide is 3 foot high, and you stand at the high tide line at precisely high tide. That's your mean high water mark that day. But if tomorrow another storm comes through and washes the beach away 5 more feet, the boundary has receded 5 more feet. So this is a flexible boundary that accounts for the fact that the laws of nature that allow our coast to migrate in and out with the seasons do not conform well to the laws of man that value precision and predictability. This bill finally clarifies how to lawfully exercise your shore rights. For purposes of transferring title to a new property owner, mean high water mark works fine. Private property rights should be preserved, but shows to the public's rights to the shore that constantly moving area between mean low water and mean high water. This bill provides an accommodation that both sides can preserve their rights and easily identified shore features they can follow without affecting the title of coastal property owners. We can have it both ways. Both sides can exercise their rights, private and public. Now, if the fear is that members of the public will expose property owners to liability, the General Assembly actually addressed that problem years ago when we passed the Rhode Island Recreational Use Statute. That will prevent against slip and fall artists who might want to claim a rock was just too slippery with seaweed on it. The purpose of that law, 3261, is to encourage owners of land to make land and water areas available to the public for recreational purposes by limiting their liability. 3265B says that CRNC rights-of-way automatically have limited liability. This bill is a great compromise that does not impact private property rights and finally makes clear to members of the public how they can exercise their constitutional shore rights, first mentioned in our colonial charter. It is a long overdue clarification of a legal issue that has simmered in Rhode Island for decades that erupts every summer when both sides assert their legal rights. This solution neatly threads the needle and lets the public use their constitutional rights without affecting the valuable property rights of coastal landowners. And I strongly support its passage. Thank you very much for the opportunity to testify tonight.
Thank you, Dennis. Are there any questions of this witness? Hearing none, I believe we have another witness, Michael Woods. Michael, are you with us?
I am.
Welcome to the House Committee on Judiciary. You can proceed.
Thank you, Vice Chair McEntee and members of the committee for having me on for a second time tonight. I'd also like to thank Rep. Cortrend and the bipartisan roster of co-sponsors who represent constituents in almost every coastal community in our state for bringing this bill to the General Assembly. My name is Michael Woods, and I'm here today representing the New England chapter of Backcountry Hunters and Anglers. I live in Rhode Island, and I hunt and fish here in Rhode Island. Backcountry Hunters and Anglers is a North American conservation organization that focuses on access and opportunity to public lands and waters, and our members recognize that access is one of the most important factors to our participation in and to the perpetuation of our outdoor traditions. With these things in mind, I enthusiastically support H. 5469, which would put the right to access and pass along the shore for fishing, foraging, and other purposes that's granted in Rhode Island's Constitution, Article 1, Section 17, into clear and practical terms, and would greatly help in minimizing conflicts between beachgoers and beachfront landowners. As we've heard, Rhode Islanders currently enjoy the constitutional right to pass along the shore for the activities that I mentioned previously, but there's no clearly defined boundary where this right can be exercised, which leads to frequent conflicts between beachgoers and adjacent property owners. We do not believe that the state's ownership boundary, as it was determined in State v. Ibison, is appropriate for determining where the right to fish, forage, and pass along the shore should be allowed, for a couple reasons. First, determining the mean high tide line, as it was determined by the court, involves averaging tide levels over nearly 2 decades worth of time, and then somehow figuring out where that level currently falls on the beach. Anyone that has spent time on the beach, especially on Rhode Island's south-facing sandy shore, knows that the shoreline is dynamic and changes frequently. So the mean high tide line, as it's projected on the beachfront today, may not be the same as next week or next year. and determining its location on any particular day would require historical knowledge and measuring equipment that's unreasonable to expect beachgoers or law enforcement officers who respond to conflicts to possess. Second, the science-based expectation that sea level will rise slowly and over time means that using such a long-term average would place the boundary perpetually underwater, which was not the intent of Article 1, Section 17, when it was approved by over two-thirds of Rhode Islanders in 1986. We believe that H. 5469 adequately addresses these issues by defining the boundary where rights granted through Article 1, Section 17 can be practiced in fair and practical terms by establishing a public easement within 10 feet of the most recent high tide line. This boundary would be easily observable to anyone on the beach with simple measuring equipment and observation, so shoregoers can exercise their rights confidently, and conflicts that arise from disputes over where the boundary lies can be dealt with relatively quickly and easily, rather than through prolonged court proceedings that result in dismissal, which was ultimately the outcome for the defendants in State v. Ibison. In conclusion, passing 5469 will ensure that all Rhode Islanders, not only those who are wealthy or fortunate enough to own beachfront property, will be able to enjoy our 400 miles of shoreline and exercise their constitutional right to fish, forage, and pass along the shore. And we urge the committee to vote in support of the bill and ultimately pass it into law. Thank you for your consideration, and I'm happy to answer any questions the committee might have.
Thank you, Michael. Are there any questions for this witness? Seeing none. We have one more witness, Kendra Beaver from Save the Bay. She's a staff attorney.
Hello?
Kendra, are you with us?
I am.
Welcome to the House Committee on Judiciary. You may proceed.
Thank you. Can you hear me?
Yes, we can.
This is you. Thank you, Vice Chair and members of the committee, for this opportunity to testify in support of H. 5469. I'm Kendra Beaver, staff attorney for Save the Bay. Save the Bay applauds Representative Cortvrend and her co-sponsors for introducing this legislation. As noted in my written testimony, Save the Bay's vision is of a fully fishable, swimmable Narragansett Bay, accessible to all. As you know, the Rhode Island Constitution has always protected public access to and use of the shoreline. The 1986 constitutional amendments reaffirmed and strengthened those rights after Ibison. With seas rising and shorelines changing, it's important for the state to ensure that the people's rights to access the shore are protected. H. 5469 recognizes this issue in practical terms. No person should be subject to criminal prosecution for attempting to exercise his or her constitutional rights when the area of permissible access is not readily discernible, especially when that line continues to move. Save the Bay proposes an amendment to make sure that the legislation cannot be interpreted in any way as diminishing the public's right to access the shore. To that end, you will see in our written testimony the following amendment for your consideration. Nothing set forth in sections 1144-26D and 1144-28B shall diminish public trust rights guaranteed in the Rhode Island Constitution. Again, Save the Bay supports this bill, and thank you for considering our testimony.
Thank you, Andrea. Do any of the committee members have questions for this witness? Seeing none, thank you, Kendra, and that concludes the testimony on House Bill 5469. So